Hello everyone, welcome to another episode of MCQs for Judiciary Exams. Let's begin today's session. The first question is, when was the Insolvency and Bankruptcy Code introduced? 2014, 2015, 2016 or 2017? The correct answer is option C, 2016. Recently, in the case of Mohammed Enterprises Tanzania Limited versus Farooq Ali Khan and others, the Supreme Court held that the IBC is a complete code in itself having sufficient checks and balances. The Insolvency and Bankruptcy Code was introduced in 2016 to address the growing problem of non-performing assets and inefficient debt recovery mechanisms in India. Next, which of the following sections of the BNSS corresponds to Section 482 of the CrPC? Section 151, Section 123, Section 555 or Section 528? The correct answer is option D, Section 528. Recently, in the matter of Muskan Enterprises and another versus the state of Punjab and another, the Supreme Court clarified that the principle of res judicata does not strictly apply to criminal proceedings, allowing a subsequent Section 482 of the CrPC petition if prompted by a change in law. Section 528 of the Bharatiya Nagarik Suraksha Sanhita corresponds to the Section 482 of the Code of Criminal Procedure, dealing with the saving of inherent powers of High Court. Next, which section of the Bharatiya Nyaya Sanhita 2023 addresses rioting armed with deadly weapon? Section 191, subsection 1, Section 191, subsection 3, Section 191, subsection 4, or Section 191, subsection 5. The correct answer is option B, Section 191, subsection 3. Section 191, subsection 3 of the Bharatiya Nyaya Sanhita 2023 states that whoever is guilty of rioting being armed with a deadly weapon or with anything which, used as a weapon of offence, is likely to cause death, shall be punished with imprisonment of either description for a term which may extend to 5 years or with fine or with both. Next, which section of the BNS deals with imputations, assertions prejudicial to national integration? Section 192, Section 194, Section 195 or Section 197? The correct answer is option D, Section 197. Section 197 of the Bharatiya Nyaya Sanhita 2023 deals with the provisions related to the imputations, assertions prejudicial to national integration. The last question is, the nature of an agreement made under the provisions of Section 20 of the Indian Contract Act would be valid, invalid, void, or voidable. The correct answer is option C, void. As per the Section 20 of the Indian Contract Act states that where both the parties to an agreement are under a mistake as to a matter of fact essential to the agreement is void. Before we wrap up, here's a question for you. Contract of indemnity is defined in which section of the Indian Contract Act? Section 124, Section 125, Section 126 or Section 127? Send the answer to this question in the comment section. Like, share and subscribe for more such content.